I'm Gloria Ledoux here on the CU Compliance Connection by League Info site, bringing you part one of a two-part overview that we will provide on the passing of S.2155, or the Economic Growth, Regulatory Relief, and Consumer Protection Act, and how it will impact, and in some cases has already impacted, your credit union. For a little background, you may remember that the Economic Growth and Regulatory Relief and Consumer Protection Act, or what we have coined S.2155, became effective on May 24, 2018, when the President signed it into law. Great news, right? We have some regulatory relief provisions that we can implement right away because the law changed. Well, sort of. The tricky part is that 2155 amended some existing laws, such as the Truth in Lending Act, Service Member Civil Relief Act, the Home Mortgage Disclosure Act, and the Federal Credit Union Act. However, all of these laws, with the exception of the Service Member Civil Relief Act, have implementing regulations. These regulations, while we know are not easy to read or understand, are actually crafted and revised by the applicable federal agency to provide guidance as to how that law will operate. So this is all to say that we are going to talk about a lot of changes to the law. Many of the changes from S.2155 have not yet been incorporated into regulation. And without that implementing regulation, we still have a lot of questions and confusion on how exactly the end result will impact the credit union's operations, policies, procedures, and disclosures. So let's talk about some of the changes that credit unions can anticipate. Let's start first with some of the changes that have already made their way to regulatory amendments. NCUA wins the prize for jumping to amend their regulation first. Effective on June 5th, 2018, credit unions no longer needed to count business loans secured by 1 to 4 family dwellings, no matter the occupancy status, towards their MBL cap. This was a result of amended definition within S.2155, which is now reflected in 723.8 of NCUA regulations. However, it's important to note that credit unions will still need to consider these as member business loans for purposes of 5300 call reporting and other applicable portions of NCUA Regulation Part 723. Jumping into another change from S.2155, Regulation V, which implements the Fair Credit Reporting Act, was also amended already to reflect a change from S.2155. While this amendment doesn't address any new requirements for credit unions specifically, more for credit reporting agencies, it is important for credit unions to be aware of the changes, especially when dealing with members who have put freezes on their accounts. The summary of consumer rights was updated in the regulation and must be provided by a CRA or credit reporting agency whenever it makes a written disclosure of information to the consumer. It may need to be provided by employers, for example, taking adverse actions related to employment, if in connection with a credit report. The summary of consumer identity theft rights was also amended and is provided by the CRA when a consumer reports that they are a victim of identity theft. Procedures were also part of the amendment for CRAs when placing credit freezes. A freeze must be done for free and within 1 business day of receiving a request by phone or 3 business days by mail. CRAs must confirm the freeze was applied and provide instructions on removing it within 5 business days. One helpful benefit for credit unions and their members is that the CRA is able to confirm to third parties that a security freeze has been placed on the file. The Home Mortgage Disclosure Act, or HMDA, was also amended as a result of 2155. Credit unions probably remember pretty vividly that Regulation C, which implements HMDA, just recently went through significant amendments that became effective on January 1st of 2018. Therefore, when 2155 passed, the industry was wondering how these changes would impact this newly revised regulation that we just had. We were literally just getting acclimated to all of the changes. Well, finally, on August 31st, 2018, the BCFP, or the Bureau of Consumer Financial Protection, issued an interpretive and procedural rule to implement and clarify the requirements that resulted from 2155. In a nutshell, credit unions that have originated less than 500 covered open-end lines of credit or less than 500 closed-end mortgage loans in each of the 2 preceding calendar years will be eligible for a partial exemption and will only need to report HMDA data on 22 data points that were outlined in the BCFP's interpretive guidance. However, one thing to note that has caused some confusion is that currently credit unions are not required to report any HMDA data on covered open-end loans if they originate less than 500 in each of the 2 preceding calendar years. However, credit unions need to remember that that threshold of 500 that's right now included in the definition of a financial institution is only applicable until 2020. At that time, the threshold is supposed to decrease back down to 100. Therefore, presumably, after 2020, credit unions that originate more than 100 covered open-end lines of credit, but less than 500, would be eligible for that partial exemption and would only need to report HMDA data on the 22 data points for those loans. For those credit unions that qualify for the partial exemption, here's a screenshot of the amended data. On the right-hand side, and outlined in red, labeled unchanged by the Act, are the data points that credit unions will need to report on for covered loans. Those credit unions that do not qualify for the partial exemption because they originate more than 500 open-end covered loans or closed-end mortgage loans are still required to report on the full list of HMDA data points that became effective on January 1st, 2018. Without an implementing regulation, the changes in 2155 amended the Service Member Civil Relief Act on the same day the law was signed into effect on May 24th, 2018. While this doesn't amend any credit union's procedures, this does make permanent the protections for service members, limiting the ability for foreclosure within 1 year after military service unless there is a court order. S.2155 also made some changes to the Secure and Fair Enforcement for Mortgage Licensing Act of 2008, or the SAFE Act. Effective on November 24, 2019, the SAFE Act allows registered mortgage loan originators, or MLOs, or state-licensed MLOs 120 days of transitional authority to originate loans when moving from a federal depository institution to a non-depository institution, or when they're moving across state lines. The MLO is permitted the authority to act as a loan originator if they meet certain conditions. Okay, now we're going to start talking briefly about some of the changes that were made as a result of 2155, but we've yet to see the implementing regulation change. Therefore, before credit unions implement any of these changes, we would encourage you to consult with your legal counsel. Additionally, credit unions should be on the lookout for upcoming changes to that applicable regulation to conform to some of these changes we'll be discussing. For those credit unions that provide private education loans, there were some changes that will be applicable to loans originated on or after November 20th of 2018. The first is a prohibition on the credit union from declaring a default or accelerating a debt against a student obligor on the sole basis of bankruptcy or death of a cosigner. The second is protection for cosigners if the credit union learns of the death of a student obligor. Within a reasonable time, the credit union will release any cosigner from the obligation of the private student loan and notify them accordingly. Another change in the Truth in Lending Act has to do with mortgage loans and the qualified mortgage safe harbor protections. Within 2155, there was an additional opportunity added for credit unions to maintain that qualified mortgage safe harbor if they are under $10 billion in assets and hold that mortgage loan in portfolio. There will still be some requirements to comply with, including the limits on points and fees, limits on prepayment penalties, and certain other provisions under the ability to repay rules, which we are still waiting for. However, it doesn't appear that the credit union will need to follow Appendix Q of the ability to repay rules. Instead, the credit union will need to consider and document the consumer's debt, income, and financial resources. That concludes our first overview of changes resulting from the passing of S.2155. We'll have another session where we cover more of the changes that credit unions can expect to see within regulation. As always, thank you so much for joining us at the CU Compliance Connection by League Info site.